Продовжуємо засідання після перерви.
Let's resume the session after the break. Please invite Kryklyva Tetiana Hryhorivna.
Доброго дня.
Hi.
Розглядається питання щодо відповідності кандидата на
We
посаду
shall
судді
consider whether the candidate to the High Court judge position, Kryklyva Tetiana Hryhorivna, is compliant with the criteria for the current competition. PCIe members are present. Names follow. Norman Oz joining us by video. HQCJ members are present. Names follow.
Роман Кадисюк, Надія Кабецька, Ігор Пушнір, Олексій Омелян, Андрій Пасічник, Роман Сабадаш, дистанційно, Руслан Сидорович.
Roman Sabadash joining us by video.
Ви маєте право заявляти відвід,
You have the right to make motions, make recusals, voice your objections and opinions. Do you have any recusals? No recusals. Thank you. The rapporteur in this issue is Sidorovich Ruslan Mikhailovich. Thank you. So, I will announce a short report. A competition to the 23 vacant judges' position at the High Court and the Appellate Chamber of the High Court was announced. Tetiana Hryhorivna Kryklyva approached the Commission as an individual compliant with the requirements of Clause 1, Part 1, Article 28 of the Law of Ukraine on the judiciary and the status of the judiciary and legal system. As a person having a judicial experience at least 5 years, the candidate was admitted to have a qualification test and participate in the competition. The qualification test was scheduled and the order of stages was determined by the decision of the Commission and by the decision of the Commission as of February 4th, 2026. The results of the first stage of the qualification test was published. The candidate earned 331.21 points and was admitted to the second stage of the qualification test. The candidate graduated from the National Law Academy named after Yaroslav Mudry in 2007 and earned her degree in law. She has an attorney license from June 22, 2007. In 2011, the candidate graduated from Kyiv National University named after Taras Shevchenko and earned a degree in accounting and audit and earned her economist's qualification. No information in the candidate's profile regarding academic title or academic degree. Regarding professional activities of the candidate, by the presidential decree of November 7th, 2013, the candidate was appointed to the judge's position at the Novosanzhary District Court, Poltava Oblast, for 5 years. By the presidential decree as of April 11th, 2019, the candidate was appointed to the judge's position of the High Court. This is general information regarding the candidate, and in my opinion, as a rapporteur, some issues previously raised by CSOs need to be considered in the closed part of the session, but we can discuss it when we approach these issues. Thank you. Okay, thank you. Do you want to add anything? Would you like to add anything? No? Then over to you, Robert.
Thank you, Mr. Chair. I believe that you are the rapporteur, Jessica. So the floor is yours.
Thank you, Robert, Mr. Chairman. Good day. Tetiana Hryhorivna, may I call you by your first name? Okay. My name is Jessica Lott Thompson. I'm a lawyer from Canada and a former prosecutor. I'd like to introduce you to the members of the PCIE. You've heard our names from the chair of the HQCJ, but I'll just let you notice that Norman Aas is on the screen to the left-hand side. He is a former prosecutor and lawyer in Estonia. To my far left, we have John O'Sullivan, who is a former judge and former prosecutor, now retired from the United States. Robert Broekhuizen, who is a former prosecutor and lawyer from the Netherlands. Judge Gabriel Jutkate-Garantsiene, who is a judge from Lithuania. And together, our role is to assess the integrity and qualifications for competency for this competition. Do you have any questions for me before we begin? So
No,
I'd like to
no questions.
state for the purposes of transparency some details about how this process works. We have already reviewed a detailed dossier compiled by our secretariat involving materials from different agencies, from CSOs, and we have also exchanged several rounds of written questions where you've had an opportunity to provide documents and detailed answers in writing to many of our questions. And so I would like to, just as we begin, thank you for your transparency and thoroughness in responding to our written questions. It's very important for candidates to participate fully in the process. But I would also like to let you know that many of the questions I will ask today are a repetition of issues that have already been raised with you. I think pretty much all of the issues that we will discuss are things that have already been discussed in writing. So please feel free, if you wish, to repeat the answers that you have already provided in writing. It's okay, you don't have to give anything in addition, but if you wish, you may. You're free to provide additional information, and we'll take it from there. Okay? All right, so I'd like to begin with some sort of simpler questions. And I understand that there are some issues that we're all aware will need to be discussed, likely in a closed session. That's something that we can discuss any motions for closed session later in the interview. I'll first attempt to deal with the issues that don't require a closed session. So my first area of questioning relates to some significant financial transactions and loans that your family has had just in the last year. So in April 2025, you and your husband purchased a house, a residence, and a land plot for approximately 4 million hryvnia. And around that same period of time, your husband received a private loan from a family member. And you later also received a substantial monetary gift from your parents. Can you please explain the timing and the sources of these funds? How did these family members, who are very generous, it sounds, have the funds to be able to provide to you and your family?
Добре. Я почну послідовно.
All right, then I will start answering from the first question regarding the transactions to purchase a house and land plot. They were divided in time. Indeed, my husband and I, we purchased a house in Kyiv Oblast, And we considered such a possibility after the full-scale invasion started. We needed a housing that would be safer than an apartment in Kyiv city. And we were looking for a private house that could satisfy our needs and be in line with our budget. Moreover, my husband and I also considered taking a mortgage. Now, in this country, there is a program, Ye Osela, housing program, that enables those who don't have housing to purchase housing at a lower rate than a general mortgage. So for common citizens, it's 7%, and beyond that program, it's 10%. So we turned to different banks, and we picked and chose one bank that allowed us to benefit from this preferential loan, preferential mortgage, and that lasted for a considerable amount of time. And in January 2025, we found a private house. This is not a townhouse, it's just a regular village house, and it is eligible to participate in Yeosela housing program. And after we have accumulated the money we had, the bank proposed us to have a mortgage for the first 50% of the amount. And because we liked the house and we lacked a part necessary to cover that part, my husband asked for a loan from his brother. And this is not the first time when we ask him for that. He is a well-off man. He can afford it. So after we've accumulated the money, we bought the house. We paid 50%, and 50% was covered by the mortgage costs. Later on, my husband got a court decision on recovering of his judicial remuneration, and with that money, we paid back the loan taken from my husband's brother, and now we only repay our mortgage. Next, regarding my parents' loan from my parents. In 2016, my parents purchased an apartment in Poltava. They used it partly for themselves. They stayed there, lived there. Sometimes I would stay there. And that apartment was used to lease it and to earn income. Despite that, because of a list of personal circumstances, my parents decided to sell that apartment, and the amount of money, the parents said that they were afraid to keep it in cash, and nor did they know how to use it in order to keep the value of the money. So my father decided to transfer the whole amount of that money to me. Part of that money, I kept it on my bank account, and I bought domestic bonds, government bonds, military bonds, in fact. And the rest of the sum I used to buy dollars, and this money is kept. I keep this money at this time they are not being used in any other way. And that is it.
There's a couple issues that you have raised that I'd like to follow up with you on a little bit more. So you mentioned the loan from your husband's brother that you and your husband received. Your husband has repeatedly received loans from that same relative, including a loan of 50,000 US dollars in 2019 and another loan in 2025. Can you explain the nature of this financial relationship? And can you please give us some more information about how the lender can have sufficient funds to be able to provide such high loans on a frequent basis?
Мгм. А, Всього позик у брата
Well,
чоловіка
the general amount of loans exchanged between my brother and my husband and his brother was 3 in 2019, $25,000 and $25,000. So we split that loan for both of us, myself and my husband. And then 2025, we asked for that loan to buy a house. Both in 2019 and in 2025 and before, my husband's brother for a long time has been leasing commercial facilities, paying taxes, and declaring his income. And I have provided certificates proving his financial state that prove that he earned net income above 2 million hryvnia per year. So his financial state enabled him to provide us with loans. We have a good family relationship with him, and he did not ask us to pay interest for using that money, and we, in our turn, paid back the loan on time, and that stimulated our relationship even more. And in 2025, he was able to give us another loan.
Provide some information about how these loans with a family member were formalized and repaid? Did you create a loan document or a written agreement, particularly since some of the funds were reportedly provided in cash, not through a bank transfer, since the loan in part would have been in liquid cash? How were these loans formalized and repaid?
Між нами було укладено письмові
So
договори.
we concluded a written agreement regarding the loan,
І повернення також було оформлено
and
розписками.
when we paid back the debt, we had a written document, a receipt, and the money returned to my husband's brother's bank account. When he was absent from the territory of Ukraine, he stays in Spain mostly. He lives there mostly. And in order to pay back the debt, I made bank transfers from my account to his account.
Okay, thank you. I'm going to move on to another topic now. I'd like to talk to you about the issue of judicial transparency and the restriction of access to court decisions. So, some details about how court decisions are published and made transparent within your work. So, in January 2025, you issued a judgment approving a plea agreement in a specific case, and you are aware of which case. We've discussed this and provided you the number, but it's not necessary to discuss it in this transparent hearing. And after this decision was rendered, the entire text of the decision was restricted from public access through the Unified State Register of Court Decisions. I understand that there is a procedural step where a court decision can have certain elements which must be maintained as confidential or anonymous, either through anonymization by initials or through redaction of a partial information in that decision. But that the procedure is often to use a one-click method and to restrict access to the entire decision rather than creating a redacted or partially transparent version. So in order to maximize the transparency, can you please explain why, with this particular decision, why it was necessary to restrict access to the full text using this one-click method when only certain details were actually required to be transparent? I understand also that it's quite difficult to reverse this step if the one-click method has been selected by the judge, and that this creates a systemic issue for transparency. Can you please comment on this case?
Ну, це підняте
Yes,
питання
sure.
досить дійсно важливе.
So you raised a very important issue.
Тільки глибоко не аналізувала
I haven't analyzed
ризики, про які ви зазначали.
those risks
Однак я можу
in much detail,
прокоментувати
the risk
наступне.
that
Що
you
стосується
have
цього
mentioned.
конкретного рішення,
But regarding that particular decision that you are asking about,
далі, проте я поясню,
I
що
cannot indeed go into details, but I will explain that
цієї
the
справи
consideration of that
відбувалося в
case
закритому режимі.
happened
Тобто, перше
within closed session
розпочати слухання
before
справи це
we
була,
started hearing the case.
угода про визнання
It was a
винуватості,
plea
і,
agreement,
починаючи з оголошення обвинувального
and
акту, тобто практично вся інформація
from the moment
відбулася в
when
закритому режимі. Це
the
було
verdict
пов'язано з тим, що
started being
угода
pronounced,
з
we switched to the closed
була
session.
укладена на стадії,
And
ще
the plea
досудового
agreement was concluded with the
розслідування
suspect
кримінального
during the pre-trial.
Цей обвинувачений мав надати
The suspect was supposed to provide a statement, disclosing statement regarding other organizers of a criminal scheme. And the circumstances of that proceeding related to a legal entity whose property needed to be confiscated. And the decision was announced in a closed court session. This is why the full text of this court decision is closed from the public domain. Despite that, I believe that there are some aspects that need to be taken into consideration. Article 22 of Criminal Procedural Code of Ukraine, the law of Ukraine on the access to the court decisions, the access of the public. Those willing to get familiar with court decisions need to have a possibility to do so. But in this context, we need to strike balance. If there is a risk of pre-trial secret being revealed, or the suspects are running a risk to be informed of the main offender, or that the evidence may be may find itself at risk, then the secret needs to be preserved for a certain period of time. After I got your request, I wondered after which period the court decisions become public. For some reason, I was confident that any court decision becomes public after a certain period of time. Why? Because there is there are some decisions made by the investigating judges.
Hryhorivna, let me ask some follow-up questions because we do have some limitations on time and we have many issues to address. I'm aware of the open court principle and also the need to balance the rights to privacy as well as the right to the transparency and openness of the administration of justice. These are challenges that are faced by justice systems around the world, including in my country and of course also in Ukraine. Are you aware that Ukrainian law generally requires the open court principle, that the publication of a court decision must be made, and that the law requires that the decision be published with maximum transparency when there is only a small piece of information which must be redacted, that in general, the decision must be released and the partial information be redacted. Can you provide a brief comment about your understanding of the law in this area? Please, like 1 minute or so, very brief indication.
Так, дійсно, не всі
Yes, indeed.
інформація завжди є в закритому
Some
режимі.
information can be heard openly. And there are functionalities, modes that enable us to redact information. There is an IT department that sends us guidance on how to use the toolbox, and the toolbox is quite complicated, in fact, and in cases when some information needs to be obscured, then it should be only the information for which the closed court session was applied.
It sounds like perhaps there are some technical limitations. So thank you for your answer, and we'll move on now to another question. I'd like to talk to you about recusals and specifically several proceedings relating to the Kyiv Administrative Court, the so-called OASK tapes cases. In September of 2022, you applied for a recusal on one of these cases, which was granted in relation to a potential for conflict of interest or apprehension of bias because of a family member who had been involved in as part of the administration of justice of a different stage for a procedural motion. Can you please explain how this situation arose and how recusals are handled in your work?
Саме в цій конкретній справі
So in that particular case
в суспільстві має таку назву
that received that nickname, I did not make a recusal in that case, and this is an incorrect information. I did not make a self-recusal in that case. One of the attorneys of the suspects demanded my recusal because my husband, Kryklyva Vitaly Viktorovich, had taken part in the proceedings at the stage of pre-trial. As a general rule, such cases exist regarding all the judges. The judge that reviews the recusal for a different judge cannot be recused from the case. After we saw the investigating judge's decision, we learned that the recusal was about the right of the suspect to get familiar with the materials of the case. So it was as if the detective hadn't provided the suspect possibility to get familiar with the case files. And the investigating judge concluded that the defense
на ознайомлення.
had appropriately provided the possibility to get familiar with the case files. Because that case was notorious, my colleagues decided that in order to eliminate any doubt about the panel of judges' bias, they decided that recusal needed to be satisfied, but I didn't make a recusal in that case.
The next two areas of questioning that I'd like to discuss are areas that I will just identify in advance, maybe issues where you as a candidate would like to make a motion for a closed session. This is your choice if you wish to make this motion. But I'll just describe the first issue. The first issue relates to the allocation of official housing. And the second issue relates to the relationship with the defendant in a corruption case. So we'll deal with the issue of housing first. If you wish to make a motion for a closed hearing, now is the time, or I can attempt to make my questions as general as possible, and we can proceed from that basis.
З дозволу головуючого,
With the permission of the chairman, I, as the commission member, propose to discuss this topic in a closed session because these questions not only relate to the candidate, but indirectly they relate to the other judges and the court in general. So it seems to me that to preserve the authority of the judiciary and to allow the candidate to explain everything in full, when it comes to the housing, I suggest to discuss it in a closed session, but it's only my initiative. May I express my view? Yes, of course. Excuse me, but I am ready to discuss the topic of the housing publicly because there was information in media and I wasn't able to provide an answer to these requests, and I am sure in my integrity and correctness of the decisions made. So I'm ready to answer openly. As to the second question, yes, I would ask to discuss it in a closed mode because the information will also be related to other people. Okay, then I accept to discuss it in the open format. Okay, then I suggest we keep discussing this topic related to the housing in open mode, and after that we will consider your motion to talk about other circumstances in the closed mode. Okay.
Thank you, Mrs. Tetiana Hryhorivna. I'm going to present to you because in the interest of time, we'll inform our listeners that these matters have been discussed in detail with you in writing. There have been exchanges of a great deal of information and timelines, and you have provided us with a lot of information. I will ask leading questions which provide a lot of detail and allow you to just answer yes or no so that we can establish some of the basic facts and then have some discussion of the details, if this is okay for you. So in 2019 to 2020, you served as the head of the Housing Commission of the High Anti-Corruption Court. And at that time, there was the issue of allocating service housing to judges, which included your spouse, Mr. Vitaly Kryklyva, and later yourself, because you were both being considered for the allocation of housing, which is your entitlement as a member of the court. I will ask you, we will discuss later a little bit more about your role in that capacity as head of the Housing Commission. According to the decision of the meeting of judges of the in November of 2019, there was a 4-room apartment that was allocated to your spouse, Mr. Kryklyva, for a family of 4 persons, which included yourself. That was in November of 2019. Subsequently, in January of 2020, your spouse submitted an application to suspend the allocation of that apartment and reduced his declared family composition. And then the next step in March of 2020, there was a decision made by the Housing Commission to reallocate the exact same 4-bedroom apartment, which had been allocated to your spouse, and to now reallocate it to you. But again, describing a family of 4, but with a different composition, only yourself, your daughter, and your 2 parents. So can you please explain some details about the role that you played in these decisions and why the same apartment was assigned first to your spouse and then to you? Please explain how you dealt with the conflict of interest issues that are inherently obvious as the head of this body making housing decisions, while also yourself and your spouse receiving housing and changing hands during this time.
Я зараз спробую коротко, але
I
послідовно.
will try to be brief, but explain everything step by step. From 2019 till today, I am the head of the Housing Commission. And for our family with Vitaly Kryklyva and for other judges, a decision was made on inquiry of service housing. And these premises were purchased by the court to ensure the needs of the judges. So it was not the situation when the housing already existed or was transferred from the self-government bodies. At the moment when Kryklyva sorry. Do I have a few seconds? Can I explain everything step by step? It might take up to 4 minutes, let's say. Okay, the main thing is to explain everything, but considering the general time frame. Yes, I will try to be quite concise. I have the order here. So in 2019, there were 33 judges asking for housing, service housing. Kryklyva was a candidate to get such service housing in view of the composition of his family, myself, his daughter from his first marriage, and our child. And, the decision of the Housing Commission was made in view of this composition of the family. The High Anti-Corruption Court purchased the service housing considering the number of people in the family, and it was done within a limited time period and a little bit non-typical, but a legal procedure was applied that the judges in need of service housing was looking themselves for the facilities that would satisfy the requirements of housing legislation, and they would suggest these premises to the court. So that was the procedure followed. During the meeting of the Housing Commission, a decision was made to provide such an apartment to Kryklyva with his family. According to the law of Ukraine on prevention of corruption and recommendations of the National Agency for Corruption Prevention, I was not voting for this decision. The decisions were made by other commission members, and everything related to the preparation of materials, it was the powers of the Secretary of the Housing Commission, and the decisions were checked by the deputy head of the Housing Commission. After the decision of the Housing Commission was issued, the documents are transferred to the assembly of to the meeting of judges. The judges assess the materials, and the decision is made on the allocation of the premises. After the decision of the meeting of judges, it is then decided to transfer the materials to the self-government body to issue an order.
На грудень місяць
As of December 2019, that order was already drafted for Kryklyva. Despite that, we had some troubles in our relationships during that period, and they were quite significant. And it led to us stopping living together. And so there was already the order ready. Kryklyva could receive it and basically use the service housing. But if since Hack judges are followed by the public, his position was that he couldn't receive and accept that order and sign the agreement if he wasn't going to live there. So he, in January 2020, he refused to receive this order. After that, I applied to get service housing. At that moment, I submitted such a composition of a family: me, myself, my daughter, and my parents. Why did I provide this composition? Because when I moved to Kyiv, my parents also moved and helped me with childcare. By the way, I mentioned these circumstances during the interview with the High Council of Justice when I was first appointed to the Hague. But there was a question to me whether I was going to take a maternal leave. And so the decision was made by the Housing Commission and later by the meeting of judges, and I received the service housing. I would like to emphasize that I only wanted to honestly reflect the people who would live in that service housing, and I had no other hopes. I sent the documents to the Hague, and I would like to draw attention to the provision 12 of the procedure of Hague. I could apply for this housing even if there was only me and a minor child, because back then all the judges of the Hague in need of service housing were provided such service housing. And the provision 12 states that in exceptional cases, if there are no other options, a judge can receive
Ms. Tetiana Hryhorivna, just to give you a last few seconds to finish your statement, and then to conclude your answer at this point, I'll ask you some additional questions.
Я хочу наголосити, що
I would like to stress
воно виникло у зв'язку
that this issue emerged due to some circumstances when I considered certain criminal proceedings. If you allow me, I will inform why it happened. But I was acting according to the law. I was following the procedures, and so there was a service housing purchased to provide it to the judges of the Hague. and this right was used legally.
So you described that when you took over the housing, this 4-room apartment, your parents were part of your family at that time. You've also talked about how your parents have an apartment in Poltava, that they have their life in Poltava. Can you please explain when your parents came to live with you, and for how long did they live with you? Do they still live with you? Can you please explain how they came to join your close family and be sharing residence with you?
Мої батьки почали
Yes,
проживати
my
разом з
parents
нами,
started living with us
з літа
in
2019
summer
року, коли ми
2019
переїхали в місто Київ.
when we moved to Kyiv.
Вони і до цього допомагали, але і
They
після
helped
того
us even before
почали
that, but
періодично допомагати
after
з
they
дитиною.
moved, they started
Я
helping
мала
more with the
працювати,
child because I had to work,
дитина була настільки
and
малолітня, що
the
її
child
вона
was
ще рок не могла відвідувати.
so little that I couldn't enroll her in kindergarten. So the parents lived with us, but it was not permanent. So either my father or my mother would come and stay with the child. And they lived with us all the time, so more than 180 days in a year. And even up till today, they come and they spent a lot of time at ours. But before it was even more frequent. After the start of the full-scale war, it became more difficult for my mother to experience Kyiv attacks, air attacks. So the father would come
I'd
often
like to
and
just clarify,
instead.
because you mentioned that for the decision, and I will refer to the specific dates here because it's important that there be precision. So that the decision of the Housing Commission on the 19th of March 2020, you previously said today that you were not, you recused yourself, you were not part of the decision to allocate the housing apartment to yourself. However, the records indicate that on the 28th of November 2019, when the 4-bedroom or 4-room unit was allocated to your spouse, that you were part of the decision-making group. Can you please confirm, yes or no, if you were on the decision, like if you were one of the members who made the decision on the 28th of November 2019? Or on the 19th of March of 2020, please reply about both dates.
Так. Ні 28 листопада, ні 19
So neither
березня,
the decision
ні,
from 19th of March nor the
я не
decision
приймала
of
участь у
the 28th of November
ні на
were
засіданні
made in with
конкурсової
my
комісії, ні на
involvement.
зборах суддів.
I was not
Там в протоколі
joined
була
to the decision
помилка.
during the
Вона була подальше
judges' meeting.
виправлена
There was a
засіданням
mistake in the
конкурсової
records of
комісії.
the meeting, and
І
it was later
це помилка,
corrected.
на
And
яку
it was
допустив
indeed
секретар,
a
можливо, її
mistake
належно
which the
перевірила, але
secretary
якщо
made. I
ознайомитися з
probably
повним
failed to
текстом
check it,
цього
but if
протоколу,
we
то
study
там
the full
різні
text of
питання,
the
які
records kept
стосувалися
of the meeting,
мене чи Крикливого. І я
different
за ті питання
issues
не
related to me or
Там
Kryklyva
чотири питання, за
were
три
raised,
питання
and
я
I
не
was not
голосую, а
voting.
за
So
одне
there
ні
were
голосую.
4
Але
items
я
of
не
the agenda,
голосувала
and I seemingly
за
voted
свої,
for
ні
one of them,
начальника,
but
ні
I didn't
секретарки
vote,
комісії.
not for myself and not for him.
I understand that we now can move to the question of your relationship to a corruption case. I understand that also our colleagues in the High Qualification Commission of Justice will also have some questions about this same topic. And so perhaps we can discuss the need for a motion of closed session at this stage or not.
Ну, клопотання було заявлено, ви ж
Well,
його
the
не
motion
відмовляєтесь.
was
Відповідно, я
submitted,
пропоную перейти до закритого
so I
обговорення клопотання.
suggest we move to the
А
closed
потім за наслідками
session, close
ухваленого
to
рішення
discussion
можемо
of
розуміти, як
the
рухатися
motion,
далі.
and then once the
Переходимо до
decision
закритого
made, we
обговорення
will
клопотання.
have the
Комісія і Громадська рада
The
міжнародних
Commission and the PCIE have considered your motion to switch to the closed session for some issues, and the majority of votes decided that we do switch to the closed session. Let us stop broadcasting.
Ми в відкритій частині продовжуємо засідання.
We continue
Пані
our
Джесіка, у вас
interview
залишились запитання?
in the open session. Do you have any other questions, Ms. Jessica?
Пане Роберте, наша черга, так?
Mr. Robert, it's our turn, right?
Yes, it is. Please over to you, Mr. Chairman.
Добре, дякуємо. Руслан Михайлович.
Thank you, Ruslan Mikhailovich.
Дякую. Пані
Thanks.
Тетяно, я хотів дещо прояснити.
Ms. Tetiana, I would like to clarify one aspect.
Службового житла, мені здається, залишився поза
I think one
зоною
detail
для того, щоб ми,
in the context of housing, service housing, was not discussed, and it's necessary for us to understand the full story. But let's try and be as concise as possible, and we will talk about specific circumstances. Based on your explanations, on the 4th of October 2019, Mr. Kryklyva and you submitted an application. So you submitted one on your behalf, and Mr. Kryklyva submitted another application to get the service housing, right? Yes. So you applied to get 2 apartments. No, it was the list of people in need of service housing. No, in a rush, we would like to discuss all the details. When the list was formed, it was made out of the people who required improvement of their life conditions. And as you say, there were 33 judges, and you and Mr. Kryklyva including. Yes. And based on that list, theoretically, it was about 2 judges, but back then you were already in a relationship. Yes. After that, when the time came and it was a moment to allocate the housing, you refused, and the meeting of the judges voted to allocate the apartment to Mr. Kryklyva with the respective composition of the family. After that, Mr. Kryklyva refused to use the service housing, not in my interest, not to my benefit, and there was yet another change in the composition of the family, and there was a separate family in my case. And when Mr. Kryklyva applied to get an apartment with his family, including you and your child, what changed comparing to the 4th of October when you submitted 2 different applications? Over that period, did something change? Nothing changed. Nothing changed. We resided together, and one child was with us, another child was living in another apartment, but this child was included because it was a minor. And by the way, the parents were living with us, but they were not included into the composition of the family because we didn't want to increase the cost of the apartment. Just for us to have the time frame. So you submit 2 different applications on the 4th of October 2019. You submit one, and Mr. Kryklyva submits one. Then, later, you withdraw your application. your composition of the family remains unchanged comparing to the one of the 4th of October. So basically you refuse, and then your relations deteriorate. Mr. Kryklyva refuses to use that apartment which was allocated to him, and the meeting of judges happens, and that same apartment is allocated to him, and you currently live there together. We do not give the address, it's in the materials. Yes. I just wanted to clarify it to have the order in our mind. Yes, it's complicated, but we tried to maintain integrity, so that's why it's so complicated. I just wanted to understand what was the order of the events. Yes, I can get mistaken about all the dates. It seems to me that the most important aspects we had to discuss have been discussed. Maybe the colleagues will have other questions, so I will allow for it. Yes, please. Miss Tetiana, I have to ask this question. If you viewed the interview with your colleague Tubas, we have to clarify one detail. You must be ready, and it will not be something surprising for you. It is related to the counterclaim submitted. For me, as a judge who worked within a panel of judges for 10 years, it's strange to see that a majority of judges in a panel have a separate opinion. And they wrote in the separate opinion, 2 judges out of 3 wrote in the separate opinion that the motives provided in the main ruling, they basically disagreed with them. But I will allow myself to quote Article 34 of the Code of Administrative Offences states that all the matters have to be considered and decided on by the majority of judges. I am not asking about how the discussion unfolded in the discussion room, but it looks, well, in the main ruling, there has to be an opinion of the majority reflected. If the majority didn't vote like that, it's a difficult case, and from the procedural point of view, it's unclear for me, as someone who has been working within a panel of judges for 13 years. I cannot imagine how it can happen. Everything is very simple. Yes, please. My colleague and I objected against the inclusion of a link, but we had no other way due to the use of that platform D3. Well, if we look at the date of the decision, it looks like the decision was uploaded and then you discovered the text. Any other questions? Dear PCIe members, maybe you have other questions.
Well, thank you, Mr. Chair.
Дякуємо, пані Тетяна. Вам надається можливість
Thank you, Ms. Tetiana. Now you get a chance to say a few words to the members of the Commission and the PCIe. Please be concise. I would like to thank everyone for this interview. I would like to thank the Public Council of International Experts. You do a lot for Ukraine. I would like to see new colleagues, and I wish you good decisions. And as for myself, I would like to say that my reputation and my good name are very important for me. So I hope that I managed to provide answers to all the questions. Thank you. Thank you for your participation in this interview, and we will now have a